All right. Good day, everyone. Thank you very much for joining. We have a lot to cover, so we're going to get started now. The standard disclaimer is that today's presentation is a public presentation to a wide number of people. It is not intended as legal advice, and you cannot rely on it for purposes of legal advice. Should you seek legal advice, you should consult with your attorney. I think most of you know that Frier Levitt is a healthcare boutique that has a national presence. We represent stakeholders across the entire healthcare spectrum, from large publicly traded multinational corporations to small family practices. I currently serve as the chair of the White Collar Defense and Government Investigations practice. I have offices in New Jersey, New York, down by the Freedom Tower, I think it's called now. So if you're in the area, please stop in for a coffee, glass of water. I previously served as a federal prosecutor for the Department of Justice for a number of years, and as an executive for some of the largest healthcare companies in the world. Let's talk about what I'm hoping to convey to you today. Obviously, I hope that you understand the title of the webinar is a bit facetious, and the subject matter is very complex. So I worked on the government side for nearly a decade, and on the private side for even longer than that. So by no means should you listen to today's presentation, say, well, I've learned everything now, and go out and fire your attorneys and represent yourself. That said, what I do plan on trying to accomplish today is to give you a number of valuable nuggets, some very precious insight from all my experience with the government and in representing clients in the context of investigations that will allow you to better conceptualize the road ahead, what you're dealing with in whatever type of investigation you're addressing, or how to avoid those investigations altogether. I'll focus today more on the higher stakes litigations and investigations, so criminal, civil actions brought by federal and state governments, and less so on the administrative and board-related matters that a number of state agencies bring. So, as you very well know, healthcare is a highly regulated industry. The regulators in this space are often referred to as an alphabet soup of agencies. There's a number of very important distinctions between the agencies and within the agencies themselves. So, for example, if the DEA is not involved at the outset, you can be fairly confident that you will not have to deal with allegations relating to controlled substances. However, that's an overall proposition. And the FBI, for example, sometimes works controlled substances cases alone, not involving the DEA, at least at the outset. In addition, there's important distinctions among personnel within the agencies themselves that are important to understand. So again, just sticking with DEA as an example, within the DEA, there are special agents and there are diversion investigators. And it's informative and helpful to understand the distinctions between these two types of employees and the types of cases they are typically involved in. What is their scope? What are their typical duties? What does a diversion investigator do, for example, in their day-to-day compared to the types of cases that DEA special agents work? In any event, what I think is most important for you to understand is that sometimes, based sheerly on the luck of the draw, if you're dealing with certain of these agencies versus others, your options are going to be more limited. So what do I mean by that? Let's take, for example, the DOJ Medicare strike force investigation. These are groups of specialized healthcare, so-called trial attorneys that are located, usually sitting in U.S. attorneys' offices and usually using the same investigative personnel that the assistant United States attorneys use, namely FBI, OIG, Border Border Protection, who are focused on bringing cases in the regions in which they're located across the country. So you have approximately 13 of these specialized forces. Although they sit in the United States Attorney's offices in most of the regions, they do not report within that structure to the United States Attorney, the federal prosecutor in that district. Instead, they report to Main Justice, and they focus solely on healthcare cases. And what's more important is that they only do criminal cases. So for them, it's either a criminal charge or they lost. That's not the case in the U.S. Attorney's Office, for example. It's not the case in the Medicaid fraud control units across the country, although there are some variations. You should appreciate that. So, for example, the Pennsylvania Attorney General has a Mafuco strike force, a number of attorneys who are dedicated to investigating Medicaid fraud. And they perceive their civil investigative authority as fairly limited. In contrast, in New York, if you have an investigation that involves Medicaid billing, the New York Mafuco attorneys very much encourage civil resolutions of particular matters, and not everything needs to be a criminal investigation or to be resolved criminally. However, when you're dealing with the DOJ's Medicare strike force, you don't have those opportunities. So you know going in that you're either going to beat the case or convince them not to bring a charge, or else you're going to have to deal with criminal charges. That's what I mean that's what I mean when I say your options are going to be limited, and that's solely luck of the draw. Typically, the DOJ Medicare strike force deals with the bigger, higher reimbursing cases, huge dollar volumes that kind of cross different regions in the country. So it may be, for example, telehealth. We'll talk about that now in terms of the types of cases that they're focused on. But there's no rule there, and assisting United States attorneys can bring telehealth cases, genetic testing cases equally, and they use the same investigative personnel as the Medicare strike force. So again, you need to understand that when you're dealing with a particular agency, there are certain tracks that the investigation may take in the U.S. Attorney's Office versus other of these agencies, for example. So I mentioned before telehealth. It's important to, when you think about risk, right? What is the consequence of a given course of conduct? You're going to want to, capture risk, obviously, for your business, right? Because without risk, there's no opportunity. And in that respect, I think it's important to understand that there are a number of focus areas, I'll call them, for the government, for the state government, federal government, that they differ somewhat. And the two that I've identified here are, I think, well-known high priorities for the government. They've tracked these trends, the cases over time, and they typically bring coordinated actions so that they can make a so-called big splash in these areas. So you'll see cases involving telehealth announced by the Department of Justice that are essentially a collection of different smaller telehealth cases from around the country, but they're all announced together so that they can maximize the so-called deterrence effect, as well as the publicity around these cases. On the other hand, there's a number of lesser trends, lesser well-known trends that have come to my attention and that I write about from time to time. So, for example, there have been a number of research fraud cases brought, particularly in Florida, and more are in the hopper to come. So if you're a CRO or a sponsor of clinical trials, you should take notice. In addition, there's been a number of criminal cases recently involving waivers of copay, and this is in the pharmacy space, over-the-counter cards, which are cards for various items that are offered by Medicaid or Medicare Advantage plans, and supermarket coupons being given out to customers. And why I have published on these cases recently is because there appears to be a growing trend on behalf of criminal prosecutors, namely the DOJ's Medicare strike force, to bring cases. And obviously, we all know these practices have been around for some time. But as is typically the case, the government is at least a year or two behind, which makes it really difficult for someone in the space to understand the true risk of a particular course of conduct, because everyone's doing it. So it seems that it's necessary to compete, and that the government has, in some ways, by not cracking down on it, has allowed that practice to foster. That's just not the case in healthcare, unfortunately. And so years down the road, it's very difficult when the government comes knocking to say, well, everyone was doing that. It's just not a very compelling defense for the government, but you can understand the decision-making process. And I think that's important to try to convey a little bit to the regulators. And if you can imbue the conversation with the fact that this had been such a rampant practice, I think that deflects a little of the scrutiny, insofar as it's not you did something that they disagree with. It's really an industry phenomena. So that's helpful to some degree. Obviously, it's not going to move the needle completely, just as if you're pulled over for speeding on the highway. You can't say everyone else was doing 80 and get out of the ticket. So then, what do you do today, right? You may have waived copays across the board, thinking, well, look, these are LIS patients, or you may have, arrangements with referral sources, diagnostic imaging companies, and the like, and you see that there appears to be, some publicity around it. You're concerned that there's going to be scrutiny in this area, but these types of conduct occurred some time ago. So what do you do? I'm going to address that in just a bit. If you do have exposure, there are some pointers, there are steps definitely that you can take. So government investigations might arise from any number of sources, and I've listed on this slide a few of the more common areas. It would really take a whole seminar to go through the whistleblowers. That's what's referred to as so-called key tam litigation, where people sue in the name of the government because your billing manager thinks you're being aggressive in billing, so she turns around and reports you to the government in the hopes of obtaining a bounty. And those cases are filed under seal. You're not going to know about them. There's ways to try to discern, if you know the indicia of these types of cases, whether or not you're dealing with a whistleblower. But at the end of the day, you're going to just be dealing with the government regulators, because they use those sealed complaints. They have a duty to go out and investigate. And so, that's just background. There's strategies and defenses that you'll have in those types of cases. But some of these other sources of government investigations don't involve, whistleblowers. So, for example, the PBM referrals, they're really rampant today. They are being accepted. I mean, it's been happening a long time. PBMs have always had their SIUs, special investigative units, looking for trends and doing their audits. And they've always referred matters, but these days, across the country, there has been a sharp uptick in the number of cases that result in actual government investigations. And I think that's the result of a trend within the government The state MFUCOs, the Medicaid fraud control units I spoke about earlier, are becoming more and more sophisticated in this area. Unfortunately, they are not where the federal regulators are. And I say unfortunately because in the federal world, we have an established framework for resolving cases. Everyone knows, all the regulators know, okay, these are the potential options and these are how cases are typically handled, whether it be a corporate resolution. There's a framework for that. There's a framework for an integrity agreement so that the business can continue operating. That doesn't exist when you're dealing with the vast majority of state regulators. And so in the state world and the MFUCO world, there may be more arbitrary decisions based on resolution that come from, whoever the boss is and whatever their viewpoint might be, as opposed to a more cohesive stance by the government, and more predictable stance. Okay, so data mining, obviously it's talked about a lot. Just, inside baseball here, as a federal prosecutor, I had access at my desk to a tool that was actually, as a data tool, that was actually built by a colleague, very sophisticated, and you could plug in to the interface anyone's name, business, and you can receive information regarding the person's billing practices, for example. Are they an outlier in terms of a particular code? And look, this information is not admissible in court. They can't bring it to court and say his billing or her billing was outside the bell curve. However, you should appreciate that in determining when and where to bring an investigation, the federal government, state government, they don't just throw darts at a board. They take a targeted approach based on, for example, these type of tools. And then finally, cooperators. That's mostly criminal cases. They're people who are seeking to help themselves by pointing the finger at other and naming someone else. So before I talk more about the investigative process, I just want to take the opportunity to go back to something I mentioned before in terms of how do you address a course of conduct now that happened in the past? How do you try to mitigate the exposure? How do you try to lessen the chance there's an investigation, or more particularly, if there is an investigation, the severe consequences that can arise out of that? So what I can say here is that if you've pushed the envelope, taken risk for the purpose of growing your business, trying to get that hockey stick growth, right? That all young fledgling businesses essentially take. Just don't bury your head in the sand. That's the worst possible approach you can take. You have to be proactive, because at the end of the day, you're not going to be able to say, I didn't know the law. Ignorance of the law, forget about it. It's not a defense. And so if you do get asked about the practices, what you need to be able to do is tell a story. You have to tell a story, a good story, as to how it happened, and more importantly, what you did about it when it came to your attention. So let's take a specific example again. Let's say you've waived copays across the board for whatever reason. And today you're worried, and you look back and you think like, well, will this lead to some exposure? Look, if you don't have a policy in place that essentially allows you to say, when this came to my attention, I implemented a policy that says not to do it. I told my employees not to do it. I trained them not to do it. And I'm shocked as anyone could be that this happened today. If you don't have that type of policy, you need to pick up the phone after this webinar and put something in place. Copays, easy low-hanging fruit, prior authorization, billing, on any number of pharmaceuticals. We can fix this and it will help you tell that story. It will give you something to talk about down the road. And it's not limited, to the pharmacy space. If you have relationships with referral sources that are risky for any number of reasons, there are a number of steps you can take today that will help you explain what happened if you're ever questioned on this subject. And what I'm talking about here is leaning into, so-called compliance, investing in compliance. And when people think about compliance, they say, well, I don't want to invest in that at this time because it's a cost, right? It's a drag on business to implement policies. It stifles innovation. There's worries there. However, the way I like to explain it to clients is to talk about when I used to go tuna fishing, and I say used to go before kids, so I don't get to go tuna fishing anymore. But when I did, I would go hundreds of miles out to sea in my boat, a small boat by any measure. And so being out there at sea, you want to take measures to protect yourself. And I was working in the government, didn't make much money. But what I did buy every single safety device out there that I could get my hands on. Whether it be a EPIRB, which is a position indicating beacon if I'm in the water, sends signals to the Coast Guard, life rafts, backup VHF radios, spending thousands of dollars that I didn't have. And what I would say is that I hope that's the best thousands of dollars I ever spent if it's never needed. And so that's how I like to tell people to think about compliance. It's an investment you hope you never need to rely on, but it's worth its weight if you do have to do it. If you do have to explain a certain course of conduct. So back to the investigation side. If you have experience in this space, you can glean a lot of insight about the paper. You got to read the paper, and the paper will speak to you about what's this case all about. So as I discussed earlier, you look at the agency, you have insights from that. Also the type of investigation, whether that's civil or criminal. And here there's a disclaimer I have to tell you is you can't place a lot of confidence in most instances about whether an investigation will move from civil to criminal or administrative to criminal or anything. And it's not vice versa, because that's a good thing if things are moving from criminal to civil or administrative. That's a good thing. That's part of the defense strategy we'll talk about. But it's the more severe move, the evolution from criminal issue from a civil issue to a criminal issue. And so in that regard, it helps to understand the jurisdictions in which you're working, right? So your attorneys, hopefully will understand and have insight about, what different regulators' views are on a given courses of conduct. And I could tell you, for example, Southern District of New York, almost nothing that starts as a civil investigation turns into a criminal investigation. Those prosecutors, some of the most aggressive in the country, they're bringing criminal cases on SBF. Bankman-Fried, for example, they're the ones who charge them. They're aggressive. They're the front headline criminal cases. And so you could be fairly confident that a civil case in the Southern District is not going to go criminal. On the other hand, I'm going to call out the Eastern District of Pennsylvania on this one. We've had cases in the Eastern District of Pennsylvania where you're producing documents and you're dealing with a civil prosecutor, and you go in for a meeting and you say, who's this guy in the room? Oh, I'm a criminal prosecutor. Surprise, surprise. So you have to understand the potential there, and you have to understand, like I said earlier, not just the agency in terms of who your adversary is, but the regulatory body, whether the U.S. Attorney's Office and the makeup of various U.S. Attorney's offices. There's oftentimes you're not going to have that insight from the paper alone. So, for example, this HIPAA subpoena I'm showing here, when the federal government doesn't know which way it wants to proceed with the case, whether it be civil or criminal, often use a HIPAA subpoena. And so in these cases, what I tell clients, and in fact, in all of these cases, whether it be civil, criminal, administrative, it doesn't matter. it's important to adopt a proactive posture and get in there early, meet with the regulators, and attempt to put your finger on that scale to influence the direction of how the case is going to evolve from the very beginning. The more you sit back and wait, even if you're saying like to yourself, well, I'm doing what they want. I'm producing the documents on the timeline they gave me. So, this is helping to resolve the case. No, you're sitting back, the government's looking at what you're producing. They're spinning themselves up over it. They're making mistakes. They're misinterpreting it. And the more you don't get in there and correct them, the more you don't attempt to influence how they're viewing what you're giving them, the more limited your options are going to be when it comes to the end. And they turn around and they're 2 years in and they come back to you and said, we've reviewed your 1 million documents and we think you did X, 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 and Y. You owe us $1 billion. At that point, because you've waited, it's too late. You got to start back here and start influencing that process to reduce that risk. They're going to misinterpret what you've given them. All right. So obviously, understanding your particular role in the investigation is critical. The slide here is explaining the difference in the spectrum between someone being a so-called target. What's in the middle is a subject to the investigation. It's an amorphous term, or an eyewitness, right? Someone who saw a car crash and says that car, ran the red light. This is all criminal lingo. These are terminology and phrases that are limited to the criminal context, but it's often helpful to use them in the civil context because everyone really at the end of the day knows what you're asking them. And so you need to understand from the outset what the government's view is. And I try to get that insight from them very early on. Often the regulator is going to be tight-lipped, but that in itself is informative. That's why many people turn to people like myself with experience in the government, because the expectation that I have, and I think people understand on the other side, is that I did your job, and therefore I'm entitled to a certain amount of respect, collegiality, that hopefully should give me more information than someone who's not in that position. But even if it doesn't lead to them giving me a bunch of information, because I did their jobs, I think that's informative in many respects as well. So the stuff that they say is just as important as what they don't say. Let me give you an example of that. So, for example, if someone's very tight-lipped and won't say anything at all to me, what I can conclude is that there's a number of different possibilities. One is the prosecutor's a very junior guy, and he's scared to open his mouth without getting supervisor approval for everything. And that's most prosecutors, until they're about 3 to 4 years in, they're just going to be tight-lipped. And on the other hand, the other, very real possibility can be is that the case stinks. It's a weak case, and they don't want to tell me anything because they know it's a weak case. When they start telling me a whole bunch of stuff, in contrast, then I think, well, this guy's pretty confident, or she thinks, like there's no wiggle room here. That's why she's giving it all to me up front. So those are the types of interactions that are informative. Even if I'm given the Heisman, I'll be able to read something into that. And you have to use all of these different data points to inform your strategy. All right, so how do you deal with employees? This is one of the most difficult questions that I deal with from time to time. How much do you want to disclose to your employees, risk the business disruption, the anxiety, the job seeking that goes along with that? When you have your business to run, you have to stay focused. But on the other hand, some of these employees may have reported you. They may even be wearing a wire around you. So in the early stages, it's important to think about What are you going to do? How are you going to handle the subject? If you have a search warrant, the employees already know. But if you have a subpoena, the employees probably don't. And so if someone in your business has done something that has caused you to come under scrutiny, those interviews are going to provide some insight. But at a very minimum, most people will say, no, I never did that. Not me. I don't know what you're talking about, right? Then they could be guilty as the day is long. And so why is that helpful? Because at the end of the day, if that employee then becomes state's evidence and he flips and he starts pointing the finger at you, and long down the road, he takes the witness stand and points the finger, he or she can be cross-examined on X date, did you meet with attorneys for my business? Yes. Did they ask you about this subject? Yes. And did you tell them that I had nothing to do with it? Yes. And that you had nothing to do with it? Yes, I did. And in fact, that's not true. That's different from what you're saying today, correct? So those are the types of considerations that you really need to think hard about. Can you disarm these employees? Is that worth the risk of business disruption and the like? And it's really going to depend on your relationships there, the nature of the case. All right, so En-ROAD. Let's talk about that long road. What I can say is that the universal issue that all of my clients across the board have, no matter what type of investigation, is the uncertainty. And that uncertainty is extremely difficult for my clients to manage, because they're constantly thinking day in and day out, how is this going to impact me? How is this going to impact my family? What's going to come of this? What I can say is that in the vast majority of cases, I have not seen the worst case scenario arrive. And while that's not always the case, and it's not always going to be the case, the most important consideration is that you just can't speculate on how something's going to turn out. You have to trust that you've made, the single most important decision in your attorney, and that he or she will represent you to the best of their ability. It's the same as when I go out tuna fishing, that analogy again. I have to know that my vessel is going to take me home if a nor'easter kicks up, if a big storm comes through. I have to be confident my vessel is going to take me back to shore. And that's the thing that you have to be confident in your attorney, that he or she is going to go to war if necessary for you. In terms of defense strategy, do you fight? Do you wave the flag? Obviously, very nuanced and critical. I can't cover that. It's just too important here. But in terms of resolution, the one strategy that I will share with you that's universal is that in the healthcare world, the same types of behavior often violates any number of statutes: criminal, civil, administrative, board issues, licensing issues. You can find a wide variety of outcomes out there associated with any given conduct. And so my point is that there will always be cases in which someone else like you was treated differently, or how you are asking to be treated. And so I like to use that information to prevail on the regulator to treat my client no differently than similarly situated people have been treated. And that's an argument, although doesn't always carry the day. It's always an argument that is taken seriously, around which there's intensive discussion, because no regulator wants to perceive themselves as a heavy-handed ogre, right? I always build into my discussions at the end of the day, while I'm asking them for fairness, I'm also kind of combining that with an aggressive posture, a very nuanced, aggressive posture, that if they decide not to give my client the deal I'm asking for, that I'll trounce them if they take the matter to court, because I've tried more cases to jury verdict than most of them. And the way you have to convey that obviously is nuanced, but the undertone is there. I don't like to lose, and I make it clear that I'm not going to. Finally, one of the most important considerations in the decision, and even before that, in terms of, like, if you decide you're going to fight the case and you have a practice, you know there's going to be, extreme consequences if an indictment comes down, and there may be relationships that are severed with payers, PBMs, and the like. So thinking about the collateral consequences, it's never too early to start planning. And then in terms of reaching resolution, if you are going to reach a resolution, it's critical, absolutely critical, that all the stakeholders, whether it be PBMs, state Medicaid agencies, OIG, federal, are all at the table, or at least you've tried to do what you can to notice the resolution to them and get some form of buy-in or feedback, so that you can at least have some information on which you can base your decision and understand the road ahead. So for example, OIG could sign off on you billing Medicaid going forward under an integrity agreement. However, state Medicaid agency may not agree with that. So if that's the case, you need to understand, if you're going to sign a settlement with OIG, what's the state going to do? State, are you on board with that, or are you not? And plan for that. That's a really high-level overview. I was hoping to get to the end of this, as quickly as possible, so that I can open this up to questions for follow-up, to continue the conversation around some of this, or anything that I've touched on or that you want to discuss. So we have a few minutes now. If you have questions, please populate them into the chat. If you don't feel comfortable doing that, don't hesitate to reach out. Whether you're in New York, you want to stop by my office for a cup of coffee, give me a call, talk through. I'll be happy to have a consultation with you and share whatever insight I can regarding whatever's on your mind. I really appreciate your attention today. Thank you on behalf of Frier Levitt. Thank you on behalf of myself for your participation, and I look forward to assisting you with whatever your needs should be. All right, here we go. Here's a question. Go ahead. Do you have a question?
Thank you for your information, sir. I have a question that is there a time limit how much they can go back for the investigation?
Yeah, great question. It's a fantastic question. So, it depends is the answer. On a civil matter, they can go back from 6 to 10 years. That's a long time. On a criminal matter, the statute is 5 years. However, in both cases, there's ways in which prosecutors can get around those limitations. They're called statute of limitation. And that is by charging a so-called conspiracy that is continuing. And so, for example, if you have conduct that occurred 5 years ago, often prosecutors will say that conspiracy is continuing. They haven't returned the monies that were overbilled to the government through these diagnostic imaging companies. And so therefore, the statute has not expired. You should understand that argument that prosecutors are barred from proceeding is a difficult argument to make, because it's often referred to as a so-called mixed question of fact and law. And so, the law is that the statute is 5 or 10 years, but it's often put to a jury by a judge for a factual decision as to when the time bar is applicable from. So, if you're trying to make a statute argument in a case, you should appreciate that you may have to make that to a jury. And that's obviously a big risk, right? So if there's an opportunity for resolution, you have to weigh that against, going all the way and arguing to a jury for acquittal based on a statutory bar. Next question.
Thank you.
Go ahead, sir.
In an ongoing criminal case specific to Eastern District of New York, if somebody stepped up or was forced to plead guilty on something, how long does it take for that docket to be updated so that other people who are interested could see the results of that plea hearing case?
Yeah, great question. Love the Eastern District. My good friend, Jacqueline Kasoulis, former acting United States attorney there, was someone I worked with for almost 10 years. And I worked with a number of people over in the Eastern District when I was a prosecutor in New Jersey to bring a case that essentially proved on the waterfront. The Genovese family was shaking down through the International Longshoremen's Association was shaking down dock workers around Christmas time for kick-up bonuses for the family. So know the Eastern District very well. There, you're not going to know if someone has a sealed plea, and that's informative in itself, sir. Right. So, chances are, if there's a sealed plea, it's highly likely that individual is cooperating with the federal government. That plea will not be unsealed until the entire case is resolved. And in other jurisdictions, there'll be a plea, and the way you'll know about it is because it's on the docket. However, the way you'll be able to tell if someone is actually cooperating with the government in connection with their plea is if their sentencing just keeps getting pushed off. But in the Eastern District, they have sometimes sealed pleas, and you can be all but certain that that individual is cooperating with the government and is going to have his documents unsealed once the complete investigation against anybody associated with the investigation has been wrapped up.
In the event that it's not sealed and there's just a period of time between the plea and when it gets published, is that usually a quick turnaround, like a 3 or 7 or 10 day, or could it take weeks and months before they post it, in theory, if it's not sealed?
Yeah, look, I mean, the last couple of years, the court clerks weren't necessarily in the office each day, but in the regular course, you should be able to see on the docket it's called a Rule 11, the entry of the Rule 11 within a week at the most of the entry, or it's called a change of plea hearing. There's also, potential court reporter you can reach out to. There's strategies for trying to get what should be, open proceeding in court where the person, said, I haven't taken anything today. I'm of sound mind and body, and I know what I'm doing when I tell you I want to judge, when I tell you what I want to plead guilty. So that there's a transcript somewhere. If you can't get that, that gives you another data point.
Thank you.
All right. Well, I guess we have another question here. Let me take one more. I think we have time for one more. Okay, go ahead.
Hi, Anthony. Thank you. Wonderful presentation. So I'll try and make this quick. What if there's a settlement with the state AG's office that occurs, right? So everything's good. Settlement has gone through and some time has passed. I think you had mentioned that obviously there's other things that can occur with PBMs, with a board of pharmacy, with potentially even a federal, because they get curious. How are there any other ways to prevent this sort of curiosity from occurring from any other organization? So yes, I'm sure board of pharmacy will they probably do another they could do an investigation on their end to make sure that there wasn't anything yeah, well, I mean, just to kind of cover their tracks, right? And then PBMs will want to inquire, but how do you prevent anything else, like Medicare, for example, from inquiring about a settlement that has occurred?
Yeah, look, I think one principle that I think many people operate under is that once a settlement occurs, the matter's over, right? So that's a natural interpretation that anyone from Medicare will have. However, if there have been tips or reports to Medicare about a particular business that is settled, that won't necessarily preclude Medicare from looking further if the settlement is limited. Because if it's the AG, that's a Medicaid piece, right? They're not carrying Medicare's water, and so Medicare might say, like, well, we want to know what's in this for us. So in that circumstance, if it's too late, it's too late. But in that circumstance, once Medicaid starts looking at something, you'll want to, even if Medicare is not in the picture at the time, you'll want to understand through your own internal investigation whether there's Medicare exposure, and then kind of be guided accordingly. And if it's too late, there's not much you can do to kind of preclude Medicare from looking at it, except to be ready and have your ducks in a row, that if Medicare comes calling, you go in there and say, look, I looked at all my claims, there's no issues with Medicare. Or if there is, there is an issue with Medicare, let us wrap this up before it starts. We know you saw the state case, and there was a mistake made. We want the same framework. Presumably that's acceptable, and try to just kind of close the matter out before it spins out further.
Okay, so there's nothing that you should do to go, if it's already over a year, if the settlement has already occurred over a year ago, you shouldn't reach out to Medicare and see maybe just to make sure that you don't get any surprises. No,
there actually are a few things you can do. But this is kind of, I could help you with that. If you have concerns down the road about something popping up again, there are strategies specifically with respect to self-disclosures that can help a lot here. If you've already concluded a matter with a state and you've determined, okay, these might be overpayments here from Medicare, you're under an obligation to do something to return Medicare's money, and that's in your interest. So we do that a lot. We could help you with that, and that will be a way to limit exposure going forward. And just a real quick side note, the benefit to that is that while there may be some penalty, there won't be the penalties that are associated with a later investigation by the government, which often asks for multiples of whatever they think the Medicare's damages are, triple, double damages, as opposed to if you address the issue, just like we're talking about compliance, doing something now, getting out in front of it, and hoping it's the best investment you can ever make. That's something. Call me after this webinar and we'll talk further.
Thank you very much.
All right, everyone. Well, really appreciate your time. To the extent you have additional questions as you're thinking through things, don't hesitate to reach out. If we don't speak, have a wonderful holiday season. Take care.